Friends, good evening. Today I feel to share my experience with the drafting and preparation of the legal opinion. I also remember the difficulty at the initial stage of my practice. So, I believe that I should put the facts of drafting and preparing the legal opinion in a simple form so that my new friends, new entrants in the legal profession find it easy to give a legal opinion and also develop quick expertise in giving accurate, appropriate opinion on the subject matter. Before I start that how the legal opinion be drafted and prepared, a brief look is required as to what subjects, on what topics the opinion is most commonly sought. Some advocates are on the panel of the government department authorities. They are advised to give opinion as to whether the order of the trial court tribunal is appealable or should be taken to the higher forum, or whether the review is maintainable, or whether the writ petition or Article 227 petition would be required to file against certain orders, or whether the matter should be taken to the Honorable Apex Court. Now let us move forward to the preparation and drafting of the legal opinion. The most important point before starting to think about the legal opinion to be provided is the question which has come forward or which has been put forward seeking by the opinion seekers. Remember, questions sometimes are in 2 lines, 3 lines, sometimes they are in 1 paragraph, sometimes there are more than one question interrelated with the topic and with the facts. Now, the procedure before preparation of the opinion or before submitting the opinion is to completely understand the question set up by the opinion seekers. This requires 3 times reading the question with intention to grasp the actual intent of the opinion seekers. Even the objective and purpose of the opinion seekers would help the advocate, counselors to submit a proper opinion. Hence, while reading, while entertaining the question, a discussion with the opinion seeker may also help, because during verbal discussion the point becomes clear, the objective of the opinion seekers becomes clear. Apart from this, a 3 times reading of the question properly framed would help to understand the actual purpose, actual point on which the opinion has to be submitted. Therefore, one needs to go into the core of the subject matter. Before starting to draft and design and think of opinion, the question would itself help enormously to set the thinking process in motion. Sometimes the counselor is also required to assist the opinion seeker to frame a proper question. Once the question is well understood and the point becomes clear on which the opinion has to be given, then only the counselor, the opinion giver, has to read the facts. And relevant laws, the relevant procedure. Understanding the facts will help to draft a proper opinion. And in case the legal procedure is also required to be elaborated or relevant laws are to be taken support, then that would also be required to be considered and consulted. Now another stage is that while drafting the opinion, while dictating the opinion, brief facts are required to be mentioned. And any person who is reading the opinion, it becomes clear to him that on what basis, on what grounds the opinion was sought. With the narration of the brief facts, and with the relevant laws, the opinion gains weightage and becomes flawless, and also becomes point specific. So after narrating the brief facts, relevant laws, open up your mind and then write down the conclusion that on the basis of the aforesaid facts and the relevant laws, the undersigned is of the opinion has to confine to the question first important thing, and the opinion giver must answer only the question which has been framed and put forward before him for answering. Opinion should not go haywire, should not encompass unrelated or very many topics. Opinion giving means giving a specific point-wise reply to the question framed and put forward before him. Foremost important thing is the opinion must be fair and impartial. Thank you.